We're good to go, Elizabeth.
Great. Good morning, everyone. Thank you all so much for being here for this state legislative update, some of the new laws to know from 2023. As Sierra mentioned, I'm Elizabeth Newman. I am the Public Policy Director at CCASA. I use she, her pronouns. And my role at CCASA is to amplify the collective voice of our members through our statewide systems and policy change initiatives. I also develop and advocate for legislative concepts that improve the response to and prevention of sexual violence. I staff our policy committee, and I provide consultation, training, and technical assistance to our members and partners to support the implementation of these policies. As we go along, I'm going to cover some of and spend the most time on the changes to system response to sexual violence. I will cover some of the new civil protections that have been passed, and then just briefly talk about some of the changes to access care and services. There's a lot to cover, and this is going to be a lot of information, and so I do encourage you to put your questions in the chat. I will pause frequently to check and see if there are questions or comments to share. And I'll ask Sierra's help in making sure those are tracked and I see them. So just to get started, we'll go over the system response changes. These really run the gamut from starting at exam and evidence collection all the way through post-conviction. So there have been quite a few changes related to sexual violence in Colorado. So CCASA's top priority bill this session was to create a kit tracking system, and we did this through House Bill 1199, the Forensic Evidence Process Improvements Bill. The goal here of a kit tracking system is to create transparency and accountability in the handling of sexual assault evidence kits, and to empower survivors' choice by giving them access to that information about where their kit is and what the status of it is. This kit tracking systems have been promoted as a best practice throughout other places in the country, and our bill in Colorado comes with funding, which will make sure that the system is in place and operationalized by June 2025. I know that is a long ways away. It is not our ideal, but with funding and everything, we did have to push it out a little bit in order to make sure we could at least get it started. We are using a technology that is already developed, and so we hope that actually it might be a little bit faster given the fact that the technology and systems have been used in other places, and it's just about customizing it to Colorado. But we do ultimately have to wait for the Office of Information Technology at the state to get everything set up here. So it will take some time for that. The bill requires that the tracking system follow kits at every stage. And so that is from the collection of evidence to the transfer to law enforcement for handling, if the kit is sent to a crime lab for testing and analysis, and then when it's turned to law enforcement for storage, and ultimately when it's expected to be destroyed based on the statute of limitations. All agencies and facilities that handle kits will be required to participate in the system by statute. The one group that might be wondering are district attorneys' offices. They will not be part of this system, given that they don't actually have a role in handling kits. And we want to make sure that any information in the system is not available for discovery. DAs are not going to be part of the system. It will really be maintained with those who have a role in collecting and analyzing kits, and then the victim and survivor will have a separate secure page to find that information and resources as well. So not only will it show them where their kit is, whether it's been tested or not, but also information about how to reach out for help, whether that's to the law enforcement agency, to the state administrator that will be running the system, or to community-based resources. Additionally, we're really excited that there will be an annual report starting in 2026 to actually quantify the number of kits that have been collected, tested, and analyzed in Colorado. This information has not previously been collected or published, and it'll give us a better sense of the number of people that are coming in to seek forensic evidence collection and seek services, and the number of kits that are being tested, so we can better understand the problem and its scope in our state. The second part of this bill is, as we looked into establishing a kit tracking system, we learned a lot about some of the barriers that have been in place with paying for kits. So many of you are probably familiar with the SAVE program, the Sexual Assault Victim Emergency Payment Program, which is run through the Office for Victim Programs within the State Division of Criminal Justice. And the SAVE program was established in 2013, and it's always been sort of under-resourced. And so one of the things that we learned was that they were doing a lot of the work of handling requests for payment and processing that payment by hand. And that created a lot of inefficiencies. And then the program also suffered from a lack of awareness, as hospital billing staff were not aware necessarily that if a victim survivor came in for forensic evidence and were not reporting to law enforcement, that they were able to have that evidence collection and medical costs covered up to a cap by the SAVE program. But it requires that hospital billing then needs to be aware and how to submit that request for payment to the SAVE program. So part of our bill also included funding for a new payment system. We also just want to make sure it's clear that folks know it covers evidence collection and associated medical costs with that initial visit to get that medical forensic exam. So it doesn't cover ongoing costs, but if someone had come in and they had a broken arm, or they needed STI treatment or preventive medicine, that those are also covered costs. We also, in the statute, removed the language that said this was specifically for medical reporting victims and survivors. We know that folks who have sought to file a law enforcement report and initiate that investigation have sometimes also faced barriers in paying for those costs associated with their medical forensic exam. It does not eliminate the responsibility of law enforcement to pay for evidence collection or of victim compensation to cover costs that someone experiences due to the victimization. But those sometimes do not cover the entire cost, or maybe the victim comp claim was denied. And so they would be eligible to seek payment through the SAVE program. The last thing we changed in the SAVE statute is opening up a possibility for law enforcement to seek reimbursement for that evidence collection piece. We heard from a lot of small and rural law enforcement jurisdictions that occasionally, if there's just more medical forensic exams happening in their jurisdiction, that really is a factor for their budget, and it can be a barrier for survivors to seek those forensic exams. And we wanted to remove that as an issue. So we did establish eligibility for law enforcement reimbursement requests. However, it's still to the Office for Victim Programs to set up those rules and a process for how that will work. And so that is not yet in place. And they also plan to still prioritize victim and survivor costs and needs above law enforcement. So that it will take some time for that to become a reality for folks who are working in rural jurisdictions. But we do hope that that will at least remove that that burden at times that has led to some survivors being discouraged from getting a medical forensic exam due to law enforcement's inability to pay or the cost for them. I'm just going to take a quick pause and just make sure, are there any questions so far?
There is a question, Elizabeth. When do the SAVE provisions take effect?
Great question. So all of the changes to the SAVE program have taken effect now. They went into effect after the bill was passed. And the piece around law enforcement eligibility does require the Office for Victim Programs to come to develop those rules and eligibility criteria, so that while it is technically in effect, it does not, it's not yet a realized piece of the program. And then just to go back here to the kit tracking system, while the bill is in effect, the actual kit tracking system is not yet in place. We're in the process of getting it developed and applied to our program here in Colorado. And so it will have to be in place by June 2025. We hope that there will actually be an opportunity for it to be in place earlier. Any other questions before we move on?
Nope, not seeing any in the chat, Elizabeth.
Perfect. And we will have a chance to come back and answer questions at the end. If you're thinking of things, feel free to type them in and we can get back to them. The second bill to highlight here is related to criminal charges for indecent exposure in view of minors. The Colorado District Attorney's Council brought forth this bill, House Bill 1135, specifically to address indecent exposure, which I do want to be clear involves knowingly exposing genitals or masturbating to cause affront or alarm a victim, and with the intent to arouse either that individual or another present. This has now been increased to a felony charge. If this had happened virtually, like over the phone, online, for minors, it is a felony. And so the DAs really wanted to kind of level it for in person, given the trauma and harm that it can cause to individuals who experience this. The critical pieces for it to reach that felony level is that the person is an adult. So the person who is committing indecent exposure has to be an adult and 4 years older than the victim or victims. And they have to know that it's in view of a minor, and a minor is defined as 14 years and younger, 14 years old and younger. This did go into effect in June, so it does apply to incidents happening from June 7th onward. Another bill relevant for you all is House Bill 1182. This bill requires access for the public to view court proceedings online. It specifically applies to criminal cases in county and district courts. It does have a few exceptions for that, and that includes if it's a closed court, so if the courtroom has been closed by the judge, or if a party to the case, so that includes the defendant, a district attorney's office, or the victim survivor has the ability to raise concerns about whether online court viewing would cause issues related to their safety, a fair trial, or victim rights. And the judge has to make a finding that there's no other less restrictive alternative. And if that's the case, then they can prohibit online viewing. A less restrictive alternative that's been suggested is something like turning the camera off, but having for a particular testimony, or but still having that audio play. And I think one of the differences, some of you may have accompanied victims and survivors to court during COVID and went through the WebEx process. A little bit different here is that instead of entering the court as a participant, this online court viewing is really to view the room, but not to engage in the proceedings. And so they will require that the courts put up some language about how recording is prohibited and things like that, to try to protect the victims and also the defendants from having information captured and then shared out in another setting. And then, of course, there is, exceptions for if there are technology, staffing, or internet issues. This does go into effect next month, so you will see that there. I do want to make clear that in 2022, the Victim Rights Act was amended, and one of those things that was included was the ability for victims to have the right to appear virtually. So they already had that right. And it had to be arranged typically ahead of time. If they wanted a support person to be there virtually, that also had to be arranged in order to get that, login and link. So this does allow a victim or a survivor to tune into other parts of the case when maybe they're not there. If they want to, see what the proceedings happening from home or things like that without having to go through that process. But there are obviously requirements at times for when someone may or may not access online viewing, and that is the judge's call to make that court viewing restricted. I'm going to go through a couple more and then we'll go back to questions. One other bill we saw related to adjudicating cases of sexual misconduct is Senate Bill 85. Some of you may be familiar with the bill CCASA worked on in 2019 to establish a sexual misconduct advisory committee within the State Department of Higher Education. This committee looks specifically at Title IX and sexual misconduct prevention and response at higher ed college campuses in Colorado, and issues annual recommendations to the General Assembly, that's our state legislature, and institutions of higher ed. Like all committees and councils and task forces, it has a sunset review. And so this year it was up for sunset, and the General Assembly passed a bill to continue it indefinitely. So they removed a date for a sunset review. So this will continue to be a resource for institutes of higher education, as well as the General Assembly, with experts who can provide insight on best practices, issues and concerns related to this response and prevention to sexual misconduct on college campuses. Another bill related to the judicial system, you'll see quite a few of these this year. House Bill 1108 is a bill that CCASA worked on with Violence Free Colorado and the Colorado Organization for Victim Assistance, COVA, to create a task that would study judicial training, specifically looking at what other states have in place for sexual assault, domestic violence, harassment, and stalking, to make sure that judicial personnel understand these issues, the impact of trauma to memories, counterintuitive victim behavior, things like that, so that they have a better information to make a fair ruling. They also are going to look at practices that can minimize re-traumatization during the judicial process. So some of those things that have been mentioned would be, around calendaring, the words being said, the involvement of the sheriff or a law enforcement who might be present and can help intervene when there might be some threatening behavior or just concerning behavior from the defendant towards the victim survivor, things like that. They're also going to be looking at existing education and the cost for additional training. So what already is provided in Colorado and what it'll take, what resources are needed to implement something to this extent. And I will say there's also a working group that is built in here to specifically look at domestic relations cases. So they're going to be really focused on what judicial personnel and judges need to know to preside over domestic relations cases, as that's often a first appointment for a new judge in Colorado, and they may not have a family law background. But this 1108, the task force recommendations will apply to all judicial personnel, not only judges. All right, I'm going to pause here to see how we're doing on questions. Is anything coming in?
Not seeing any questions in the chat, but just encourage all of you to ask those, whether they come up as Elizabeth is presenting on these specific topics or throughout, and we can always circle back. But I'm not seeing anything, Elizabeth.
Thanks, Sierra. So the task force is meeting now, and they will continue to meet through January 2024 with the intent that the recommendations they develop will inform a bill in this next session. Another relevant bill is House Bill 1034. This bill deals with that DNA testing that after someone has been convicted, but is asserting their innocence, and there's new ability to test DNA that would potentially overturn their conviction. And so this is not something new. What happened this year is actually just expanding sort of the eligibility and laying out the process in a way that makes sure it's more accessible. This was promoted by the Corey Wise Innocence Project, which is housed at CU Boulder's Law School. And previously, it only applied to people who were currently incarcerated on a felony charge. The expanded eligibility includes people who are on parole for a felony charge, people who have been required to register as sex offenders, people who have completed their felony sentence, and those who have been found not guilty by reason of insanity. The real point of the law here is to just give them that opportunity to file a motion to a judge that they, otherwise would not have been convicted if this DNA testing were available. So it has to be that there's new DNA, that DNA testing wasn't available at the time it is now available, or better DNA testing. And the judge has to make a ruling that in order for the DNA testing to proceed, that is kind of critical to the case, that there would have been no conviction if there was favorable DNA testing for that particular defendant.
Elizabeth?
Yes.
We did have a question. Is there a timeline on when post-conviction DNA testing needs to occur?
There is not a limit to, how long after a case. So this does go into effect in October. It does not happen frequently, I will say that. The expectation is that by passing this law, it would happen more because it is open to more folks. But there do need to be those kind of qualifications of, the DNA testing being relevant to their case. And so it does give a time period or it doesn't give a time period for when that's relevant, because of course, there may not have been an ability to find DNA on a case decades ago that now is now available. And, for someone if they've been wrongfully incarcerated for that, it doesn't matter how long it's been, right? They, our position has been that they should be freed if that evidence finds them that they were not guilty of that crime. Any other questions?
Nope, they just said thanks.
Perfect. And thank you for keeping an eye on the chat for me. This year, we also saw the Sex Offender Management Board come up again on that sunset review that I mentioned earlier. This board has come up quite a few times, and the legislature has ended up kind of just kicking the can down the road. And this year, they really, forced all the stakeholders to get together and come to an agreement on what would be appropriate to establish, any changes to the existing Sex Offender Management Board. For those of you who are not familiar with the SOMB, they are responsible for approving providers of sex offender management treatment or sex offender treatment, and of establishing the standards and guidelines for that treatment. And so this board, they don't have a role with, who's registered as a sex offender or not. That's not their job. They're really looking at what is appropriate treatment and what are the standards and practices that should be followed, and who are the people who are approved to do that treatment. The General Assembly, in passing Senate Bill 164, renewed the SOMB for 5 more years, which is great because it had been renewed on really short terms, so we would kind of continue to see this issue come up. So 5 years really gives the SOMB a chance to kind of implement these changes and adjust how things are going, and see if there have been improvements to some of the concerns that have been raised. And they also made a couple of changes to the statute. So previously, people who were required to get sex offender treatment were provided a list of 2 names of providers that they could seek treatment from. The bill changed the statute so that folks would be provided the full list of appropriate or approved providers that have relevant expertise. So things like working with the LGBTQ population, working with specific languages, those types of things will still be taken into account, but someone would have the ability to seek who they feel like they might have a successful treatment relationship with. There is still a process for changing treatment providers. So I know some folks had concerns about sort of treatment shopping or provider shopping, and that is still controlled in some way by how frequently someone can change and pursue a new provider. It also requires the SOMB to work with the Department of Corrections to study the incarcerated sex offender population and the barriers to accessing treatment, along with how many folks are really remaining in confinement or incarcerated due to the fact that they have not been able to get that treatment required. And so there have been really different numbers suggested from different sides of this issue, and this is hopefully to get an accurate picture of what that is and how they can expand access to that treatment so folks can be released to the community. It also expands providers. There is a very large issue with getting enough providers. That's one of the barriers to treatment for folks who are incarcerated. And it allows more people to provide treatment as long as they are working under the supervision of an approved provider. So there is a process, as I said, the SOMB approves providers, but people who are working under the supervision of an approved provider can also become part of that treatment provider workforce, so that we can address some of those issues with people not getting access to treatment just because there weren't enough treatment providers. So those are the big changes with the SOMB. They will continue to exist and will come back in 5 years for another review. One more bill related to the system change, and that is, or a system response, and that is Senate Bill 193, which is related to notification of release. So this bill is doing a couple minor changes. One of that is to make sure that the victims have notice of at least 15 days prior to any early discharge, so that if someone were going to be released into the community, that it wasn't a surprise, right? A victim had enough time to kind of receive the notice and maybe take steps to put in safety plans or whatever they might feel like would keep them safe or address any concerns they might have about that release. It also requires any notifications about release to be in plain language, easy to understand information. We had heard from some victims that it was confusing. They weren't sure what the notification was actually saying. And then also it requires that for any parole proceedings or review notifications that are sent to victims for engagement where they have a right to be present and be heard, that the notifications are written in such a way to attract their attention to it, so that they are kind of receiving it and knowing that this is something that they can be a part of if they want to. So a couple of quick updates. Some of it is more putting into statute what is in practice in some places, just to have that consistency. In other parts, it's small changes to just make things a little bit easier on the victims for knowing that this is, coming, that the person that has harmed them is going to be released. Before we move on to some of the civil protections, does anyone have any questions on any of the other system change bills we covered?
Not seeing any, Elizabeth.
Great. Okay, moving on. There were a couple important protections that were passed this year related to bodily autonomy and safe environments. The first bill was a bill that CCASA ran related to informed consent for unconscious intimate exams. Specifically, what we're talking about here is the practice, and it's unclear how widespread it is because people are under anesthesia or sedated and not aware, but there have been cases, and we're aware of at least one happening in Colorado, where someone has gone in for surgery and has been, their body has been examined by medical students as a learning process unrelated to the medical care that is being provided. And so what this bill does is require a separate, distinct informed consent form for these types of exams to be permitted. So we didn't eliminate the practice of providing breast or internal pelvic, prostate, or rectal exams to unconscious or sedated patients. It just is that the patient needs to be informed and to consent to that practice. Studies find more than 3/4 of patients will allow medical students to learn on their bodies if they are asked. Of course, when you're going in to sign a release or to sign all those consent forms went for a surgery or a hospital admission, as oftentimes you're not reading all the fine print. And so we really wanted to make sure this was clearly communicated, that patients have a right to consent, and to consent to how many medical students that they're introduced to them. They know who will be part of their care and touching their body. It applies to medical providers, so any doctors, nurses, midwives, anyone practicing in that setting, learners, so students and residents and things, as well as the facilities. So hospitals are also required to ensure that these forms are maintained. They maintain the other consent form, so it's just kind of folding it into that process. And as I mentioned, it applies specifically to unconscious or sedated patients. There are a couple exemptions. One is for an emergency. So we heard about, you have a pregnant person in a car accident coming in, they're unconscious. The physicians need to check for the health of the fetus and the patient. Of course, that is critical to an emergency, to life-saving treatment. And so that is an exemption. However, I will say they still need to inform the patient after the fact, before they're discharged, whether or not that happened, because we did hear a lot of concern and anxiety from patients in Colorado wondering if this could have happened to them. They have no way to know. There also is, this does not interfere with evidence collection. Many medical facilities will not perform a medical forensic exam or collect evidence on an unconscious patient, unless there have been times of a judge ordering that because they want that evidence collection for a case, and there's maybe concerns that patient might not wake up before the time that the evidence would no longer be available. So it doesn't involve, doesn't interfere with evidence collection. If there are concerns that we did hear from one police department who was worried about hospitals interfering with the ability to collect evidence, that is a policy that some hospitals do have around not doing something that's not related to medical care on someone who cannot consent. But that is a hospital policy unrelated to this bill, and this bill does not interfere with any of those practices. I will also say that if someone's going in for medical care related to that breast, pelvic, prostate, or rectal region and is going to be unconscious for it, as long as the procedure, like for example, a colonoscopy, it's explained what is part of that, that they don't have to get this separate consent form. Same with things like an abortion or hysterectomy. We did hear from providers who didn't want to add more forms to that process when it's already explained as part of the care. And so if it's part of it related to the care, that is also not required to have a special consent form. It's really about those additional exams that are being performed more often for learning opportunities and educational opportunities than related to the care. And then the enforcement for this does set up whistleblower protections to make sure that med students and nurses and others who might maybe have fears about coming forward and speaking out about misconduct have that ability to be protected legally from making those complaints. There is a complaint process being established by the Colorado Department of Public Health and Environment, and there is liability for providers and facilities who abuse their power in this way, and that liability is not covered under medical malpractice caps, covered under other liability caps. So that was an issue we experienced. Overall, this is not a malpractice issue. It's not a mistake. It is an intentional violation of someone's bodily autonomy and their consent. And so that is why it is not under malpractice. This does go into effect in January of this next year. One other bill related to bodily autonomy that CCASA supported is Senate Bill 188. This was part of a 3-bill package for protecting reproductive and gender affirming care. This bill in particular establishes the legal protections. So it maintains that gender affirming and reproductive health care are legal in Colorado, that you cannot, or insurance companies and licensing bodies cannot penalize or restrict licensing or insurance coverage for providers because they provide gender affirming or reproductive health care that is legal in Colorado. It specifically limits or prohibits cooperation for state and local agencies in out-of-state investigations. And that's important here if you are especially, maybe seeing a client from another state who is seeking support in Colorado and services in Colorado. If they were to access an abortion or gender affirming care as an advocate, you would be protected from any kind of warrants or prosecutions from another state if that's where that client was from. They also prohibits any kind of regulations that target these types of providers but don't apply to all healthcare providers. And so specifically looking at things like zoning or requiring, certain other like requirements for the medical providers that wouldn't otherwise be applicable for healthcare providers, but specifically are applied to these. Those are prohibited in Colorado. And it also adds providers eligible into the address confidentiality program, so they can be protected from things like doxing or harassment. As part, I will cover one more of the reproductive and gender affirming healthcare bills later, but that was one of the 3 that are really strengthening Colorado's protections for gender affirming and reproductive healthcare. CCASA worked on 2 bills around work environments or safe environments. One is Senate Bill 172. This is the Power Act, protecting opportunities and workers' rights, and specifically it's about workplace harassment and discrimination. They updated the workplace harassment definition to make sure that it was really related to conduct and communication that was directed at an individual or a group because of their protected class status. So that applies to, gender and race, religion, color, national origin, disability, all of those pieces there. They're setting forth a stronger, more clear definition of harassment. Important for sexual harassment is the elimination of the severe or pervasive standard. In some places that's been called the one free grope standard, because judges have ruled that one instance of a noose being placed on a desk or the use of the N-word or a grope at work
I'm having anxiety today.
not been seen as either severe or pervasive enough to fall under harassment. So this bill says that if it's affecting employment decisions, interfering with your work, or creating an intimidating, hostile, or offensive environment, and it's conduct or communication due to your membership in a protected class, that is harassment. The second part of this is setting up some of the legal procedures related to harassment definition. So for one, they established that it is not a defense to say that historically, construction has been full of sexual harassment comments, sexual comments, and so therefore that's kind of a norm, and we shouldn't be held to the same standard. It says this is 2023. Everybody has the same standards for workplace harassment, regardless of historical norms in that workplace. And sorry not to call out the construction industry, but has been argued there. It also establishes the standards for employer response that would then, this is basically protections for employers, what they need to be doing in order to avoid that lawsuit for harassment or discrimination. So things like training and prompt response, those kinds of pieces are laid out specifically in the statute as an affirmative defense for employers. It strengthens some disability anti-discrimination laws. So specifically saying things like you cannot, not hiring someone because they have a disability, it has to be directly related to the job and means that their disability prevents them from being able to do the job, not that they would need accommodations, right? There are requirements to provide accommodations for individuals with disabilities, and that is maintained through our anti-discrimination laws here with this update. And then the last piece is related to non-disclosure agreements. So we heard a lot about those during Me Too and how they have been used to silence victims and survivors and protect those who have been causing the harm. So this bill establishes that an NDA is only allowed if it's applied equally, and it allows victims to disclose certain facts and terms for particular causes, like if you have a settlement, you might need to inform your tax preparer about that, what that is. Or if you are involved in certain government proceedings related to the harassment or discrimination, you are allowed to disclose those facts, things like that. So those new provisions are in effect now. And not only is that relevant for you all who might be hearing from people who have experienced workplace harassment, but you are all employees as well, or many of you. And so these laws also cover employees in Colorado. And then secondly, CCASA worked very hard at the end of session to extend these protections to students in school. So we passed Senate Bill 296. You'll see a lot of same language here with the definition of harassment that was intentional by the sponsors, who really wanted to make sure that students had the same protection in school as their teachers do in the workplace, or their parents in the workplace. And so again, related to that, conduct and communication that is directed at a student because of protected class status or perceived protected class status, and removing that severe or pervasive standard so long as the conduct or communication is interfering with their educational opportunities, decisions, any kind of educational access, or creating an environment that is intimidating, hostile, or offensive. So you see that same language carrying over from the workplace harassment bill. A couple of things that are a little bit different are this applies to specifically K through 12 public and charter schools. If a private school is getting federal funding, which many do, they are responsible to Title IX and also Title VII, which are federal laws and regulations, but they would not fall under 296 here. What we did here is basically say Title IX is kind of a standard across. This is strengthening that, going a step above Title IX requirements, and applying it to all forms of harassment and discrimination based on that protected class status. So not only applying to sex and gender. This is requiring staff training on a regular basis about how to respond to harassment, the process and policies, some trauma-informed response required in that training, as well as annual notification to students and parents about the policy and their rights, and how to access those rights should they experience harassment or discrimination in school. The specific pieces of the policy that I wanted to highlight is it does require that schools investigate complaints within 60 days, and that they're providing an update every 15 days to the student to make sure that they're aware of what's happening with their complaint. It establishes preponderance of the evidence as standard, so that's more likely than not that this happened. That's a standard across most civil and administrative proceedings. It also establishes that pattern of conduct is relevant evidence. So if this is the fourth student that's come forward with complaints, similar complaints against this same student who has been harming them, that can be considered, not that those cases are taken together, but just that this has been seen numerous times and reported numerous times can be evidence to that case coming forward. It establishes certain amnesty protection. So things like using alcohol or drugs do not then, the student reporting or being a witness would not be punished for those types of activities. Also, the schools cannot retaliate against students for reporting or participating in a complaint and an investigation. And it sets forth specific language around providing supportive measures. So what those might look like, things like allowing someone to retake a test, changing their locker, things like that, and tying into some excused absences, things related to that harassment and discrimination. So whether that's appointments, whether that's having already mental health issues were permitted as excused absences, but just tying it to that as well. We know students who have experienced harassment and discrimination can also experience anxiety or panic attacks as they're trying to go to school and see that person who's harmed them. And so making sure that those are not counting against them as absences. This bill does not go into effect until July 1st. So if you, like me, have a student who started school recently, this is not covering them for this year. It is for next year to give schools time to implement and start moving forward with those policies and trainings. So any questions on some of these new civil protections?
Not seeing any questions.
Okay, you all are a quiet group. We will have some time at the end if there are things that are coming up for you and you're just taking a moment to think about them. You can put them in the chat now, or you can raise them at the end. So these I'm just going to go over kind of quickly. They're more just so for you all to be aware of CCASA's work in other areas and other bills that are related to access to care and services for sexual assault survivors. So the biggest one is House Bill 1107, which was getting funding for victim services. Previously, Colorado has never dedicated general funding for sexual assault programs or domestic violence programs from Colorado's general fund. So we get federal funds that state agencies distribute. There have been a few things like donation, like tax write-off donations that have gone to certain programs for victim services. This is specifically getting an investment from the state of Colorado of $3 million for the domestic violence program, which is within the Department of Human Services, and funds community-based DV and now SA organizations. So that funding, $3 million, is specifically to fund community-based victim services agencies. Also, we worked in the budget. It was originally in the bill, but through the whole process came into just the budget. We had an additional 14 million to support victim services. And so that's 8 million to the Crime Victim Services Fund in DCJ, which operates the VOCA, the Victim of Crime Act funds from the federal government. So those that 8 million is folded into that pot to make sure that programs who receive VOCA funds are able to maintain services. There was a $4 million to the Community Crime Victim Services Fund, which is in a grant in the Department of Public Health and Environment, and that's specifically targeting underrepresented and underserved communities. And then 2 million to state victim assistance and law enforcement, VAIL. So those overall 17 million for victim services this year. Some of that has been those were federal COVID recovery funds, but the 3 million for DVP specifically was in that general fund dollars, which is a huge investment, and was a one-time allocation. So we are going to have to keep coming back on funding for victim services. Another bill we worked on, again related to judicial. Some of you may have seen there were quite a few scandals coming out of the judicial branch in the last couple years. The state legislature took those seriously and initiated a number of sort of reforms. This one, House Bill 1205, we worked on specifically because we heard from survivor of sexual harassment who went through the process of filing a complaint against the judge who harassed her, that there was no communication, no connection to resources. She was just really on her own. And so both for people who are specifically employees of the judicial branch, as well as those who have a work relationship with judicial departments or courts, the Judicial Ombuds Office is being created as an independent office, separate from the courts administration, separate from their HR, to provide information and resources and be a place to support people who have concerns and complaints about misconduct in the judicial branch, to give them a space to go and get information and resources and find out what their next step will be. So they're not quite an advocate. They are really there, though, to provide information and resources and referrals. And so they are there to support people who have experienced or have witnessed misconduct in the judicial branch. So people who are like DAs or public defenders, people who don't necessarily have that work relationship. If you're a victim assistant, you might still encounter or witness misconduct, and this office will be available to you. On medical care, we supported Senate Bill 189. This was the second of three of the reproductive justice and gender affirming care bills. This bill specifically, as I mentioned, the first one was around legal protections. This one specifically around barriers to insurance and care. So it not only applies to abortion, but also STI treatment and management, vasectomies, hysterectomies, contraception. It increases family planning services statewide, and it also has some requirements around HIV medication, allowing doctors to prescribe that without having to go through step therapy, which is like, you have to try this one first, and then you can try this one. So really giving physicians the ability to prescribe what is going to best meet the needs of that patient. We also supported House Bill 1218, which is related to the availability of healthcare services that are not provided at a medical facility, a hospital primarily, for non-medical reasons. So read beliefs. So this means that patients who go into an ER or hospital are not going to be surprised when they're having a C-section that they cannot also get their tubes tied, that information has to be shared with patients as they are being admitted, and also that the Department of Public Health and Environment is going to be hosting a web page for people to refer to there, where they will keep track of those types of things. There are specific healthcare services outlined in the bill But as I mentioned, it's more related again to that reproductive and gender affirming care. Although it's quite broad, there's a general bucket sort of healthcare services that patients would expect to be provided that are not provided due to non-medical reasons. And then lastly, CCASA has been working a lot to try to support more behavioral health care for survivors. We supported and worked closely with Mental Health Colorado on Senate Bill 176 and also Senate Bill 14, which relate to disordered eating prevention and treatment. Senate Bill 176 is prohibiting the sale of diet pills to individuals under 18 without a prescription. So they have to have a prescription in order to access those. That's because there's been documented evidence of a growing increase in disordered eating among young people. And we know that about a third of people who have been in treatment for eating disorders have a history of sexual violence, experiencing sexual violence. And so it really is something that is important for survivors to have that ability to access treatment. There were some regulations on treatment providers that did pass, although we had worked on some trauma-informed care standards that had to be taken out of the bill due to funding. So those were not passed this year, although we hope they will come back. And Senate Bill 14 establishes an office for disordered eating prevention. So really looking at steps that the government can take to prevent eating disorders in Colorado. I learned this year that Colorado has like more eating disorder treatment providers than many other states. And a lot of people come here specifically for that treatment. And so it is really valuable that Colorado is taking steps to make sure that that process is humane and not re-traumatizing as much as possible to individuals who are undergoing that treatment. And then we also supported House Bill 1200, which is specifically about folks who are on public health care, so Medicaid, getting access to behavioral health treatment in a time of crisis. And the bill requires that if they are not able to access it through the sort of Medicaid approved providers or Medicaid providers, that they have to pay the Medicaid has to pay for them to seek it in private providers, so outside of those approved ones, just to make sure that people can get care when they need it. So that was what CCASA's policy agenda from 2023. As you can see, we really covered quite a few areas. That's something that, you know, we try to do. And so I do want to just make sure I stop here. If people have questions about any of the bills we've covered so far or anything else you want to ask about, I'm happy to answer those now. And you can put them in the chat or Sierra, can they unmute?
Sure, yeah, I'm not seeing anyone in the chat. If you feel more comfortable and are okay to share, you can unmute yourself and ask Elizabeth any questions you have.
Well, while you're thinking, if you do, I will show my contact information. For those of you who are interested in being more involved in CCASA's legislative advocacy, I do want to invite you to become more active. We send out action alerts for bills that we need to contact legislators to support or amend or oppose. We have a monthly policy committee. If you're a member of CCASA, we are open right now for new members to join the policy committee, which meets today and every third Tuesday of the month to talk about our policy priorities, to give your feedback or insight on bills and things that might be coming forward. And also to be part of our legislative advocacy and testifying. So you can reach out to me, also Anastasia, who's here, and maybe you can put your information in the chat as well. We are the policy team for CCASA, and so if you'd like to be more involved, please connect with us, and we would love to hear things that you're interested in seeing changed or that you might want to be involved in supporting.
Elizabeth, there is a chat. I'm sorry, there is a question in the chat. Do you have any information on of stalking charges and laws?
Yes. So some of you may have seen that there was a U.S. Supreme Court case that did overturn a conviction for a person in Colorado who had been stalking and had been convicted of stalking someone here who was receiving thousands of messages on Facebook, some of them threatening, and had gone through the court process, and the conviction was overturned by the U.S. Supreme Court based on free speech. So it's a little confusing how it will affect the stalking statutes here in Colorado, because they did not overturn it based on the existing stalking statute. It really was related more to regulating and allowing free speech. Basically, you can say what you want to say without a criminal conviction unless it's a true threat, and that's really where the Supreme Court justices got involved, was in evaluating whether this person's messages were considered true threats. And I think it's very concerning. CCASA expressed our disappointment and issued a statement, really disagreeing with that ruling. And I do believe that there's been some conversations with the Attorney General's office on next steps to take to make sure that people in Colorado are protected from this type of behavior, which is stalking and harassing. If someone's sending you thousands of messages that are unwelcome, and you block them, and they come up with a new name and send you new things, saying they know where you are and things like that, that is very concerning behavior. And I know that the state attorney general's office is taking that seriously. I have not seen any efforts at this time, although we're still early, to introduce new legislation for 2024 to see if there's any kind of gaps or loopholes that could be closed through state legislation. So hopefully that answers your question. Any other questions while we still have a little time?
Elizabeth, not necessarily a question, but someone shared the biggest problem with that case was the prosecution did not address the intent of the perpetrator. And then individuals are just saying thank you for the information.
Great. I will say, for those who are interested in what's coming forward in 2024, you may have seen in the news that the Colorado Supreme Court overturned the part of a bill that CCASA worked on, Senate Bill 21088. Senate Bill 88 created the new cause of action for institutional and individual accountability for that, for childhood sexual abuse, really stating that covering up or turning a blind eye to childhood sexual abuse is also a harm, and something people should be held liable for, and organizations should be held liable for, even if they weren't the perpetrator of that. And what the bill included was a window of time for folks who had previous complaints or previous cases to come forward. The Supreme Court has ruled that our Constitution in Colorado does not allow for retroactive laws. And so they did overturn that piece of it. And some of you may have seen that our legislative champions have already come forward stating that they're ready to introduce a new bill to rectify that. It would require, because of the constitutional piece and that question involved, it will require a constitutional amendment. And so that's something that CCASA is going to be working with legislators on in 2024, is such a bill would require 2/3 of both houses to pass it, as well as then 55% of voters, which would be on the November 2024 ballot. Not something CCASA has done in the past, but we do know that it's something that survivors have really looked for in trying to hold those institutions accountable who really did have a role in their victimization. And so if people have the evidence and want to pursue that case, we don't want to take that opportunity away from them. So that will be something that you probably will see coming forward in 2024. And we're also working on developing the rest of our policy agenda. So if there are laws or things standing in your way of really providing what survivors need and the services and support that they need, please do reach out to me and Anastasia. Part of our role is to really find out where things are not working as they should be, and try to change that. And oftentimes CCASA members have been the reason for bills being introduced that, make changes to access to STI treatment and prevention following a sexual assault, or things related to the kit tracking bill. So a lot of those pieces, we hear from you all, and then we can make changes accordingly. I will also say that judicial training task force that I mentioned is probably going to come forth with a bill for 2024. And also we'll be back for more funding for victim services, because the federal funding is not going to match what it has been previously. And we know that the need is really high to maintain services and to make sure that you all can keep doing the important work that you're doing. So that's just a glimpse of what we're looking at for this next year. And if you have ideas, please do reach out. We'd love to hear from you.
Thank you so much, Elizabeth. I'm not seeing any other questions in the chat, but again, you have all of the contact information needed to reach out to our policy team here at CCASA. Thank you all so much for attending today. Kathy did put the survey in the chat. As mentioned earlier, we will send out a follow-up email with presentation and presenter information along with the survey. So thank you all so much for being here today. Again, be on the lookout for this recording on our YouTube page to share amongst your network. Thank you all so much for being here. We're going to go ahead and close out for the day. Have a good rest of your week, everyone.